This is the Hidden Killers Podcast with Tony Bruschi.
Featuring defense attorney, Hidden Killers daily contributor, and host of the Defense Diaries podcast, Bob Motta.
Not a big surprise here. The motion to dismiss in the Bryan Kohberger case denied by the judge. His attorneys arguing that there was evidence withheld from grand jurors, juror bias, insufficient evidence for the initial indictment of Bryan Kohberger. Judge said, nope, we did everything good. He is still indicted. Nothing is going to change about that. The house in King Road also up for debate right now on if it will be torn down or not. We're going to talk about that as well. Joining me to discuss, host of the podcast Defense Diaries. Go and download that. Bob Motta, defense attorney. Bob, let's start with the motion here. I don't think, like I said, anyone's surprised by this, but from a defense standpoint, was there really truly any legs to this, or was this just an attorney doing their job and vigorously defending their client?
The latter. It was definitely just an attorney doing her job, filing what she felt needed to be filed. Look, like when you're talking about pretrial motions in a case like this, what you're trying to do as from the defense side of it is avoid down the road missing steps that should have been taken so that this thing gets kicked back on appeal if he's convicted. So, I mean, like you're going to see motions that the one with respect to, and there were two motions attacking the grand jury indictment, right? There was the one that you were just talking about, and there was the one that went kind of on the historical argument saying that, the Constitution of the state of Idaho, basically, which would be the law of the state, like that, like the Constitution, the state Constitution of Idaho would be the highest form of the law there. And that essentially she was arguing that, look, the Constitution says that in a grand jury, that they basically have to meet the same standard that they do in a trial, which is beyond a reasonable doubt, which is absurd. Mm-hmm. But she was technically, because at some point the legislature in Idaho changed it, and that was in writing in terms of, it's a different standard. It's a much lower standard, a probable cause standard for, to get an indictment. And, that was in writing, and her argument was, well, the legislature can't override on its own accord what the Supreme Court has written in terms of, or not the Supreme Court, but what the Idaho Constitution says. So it was a technical argument. I knew it had zero legs. Mm-hmm. I mean, clearly they were never going to say, okay, yeah, you're right. The burden of proof at the grand jury is beyond a reasonable doubt. You knew that wasn't going to happen. I just kept saying, I think that was probably an argument that Ann Taylor talked about at dinner with other lawyers for years. And it was just kind of waiting for her opportunity to make it. It's that thing had zero legs. From the defense side of it, I knew that there was zero chance. And frankly, had they been granted, they would have just re-indicted him.
Exactly. Yeah. I mean, it really would have gone absolutely nowhere. I mean, things like this, are we expected to continue to see motions like this put out there to keep delaying, to keep slowing down the process of this, to push that trial out as far as they possibly can? Is that the goal right now, to get this thing kicked into late 2024, 2025, however far they can push it? So it's, there's a little less sting to this whole story, or are they wanting to get it into the courtroom quicker?
Well, there's two aspects of it. Yeah. And I can just tell you from a defense attorney's perspective, the motions that have to get filed, and they'll get progressively more interesting. Like the early motions, this thing was kind of a pro forma motion where, you file them just attacking the indictment initially. When we start getting into suppression motions, that's where we're going to get into the real stuff. And we know that there were issues with the house in terms of there were kids running around in it for hours before law enforcement was called. There's going to be issues with whether or not the crime scene was compromised. There's going to be issues with respect to, the sheath and whether or not that's admissible in terms of, the DNA. And, there's going to be either a Daubert or a Fry hearing on whether the DNA is sufficient to be admissible as evidence. So all those things are going to happen. Yeah. And to answer your question is like that just takes years, man.
It
like
just is what it
this
is.
this isn't a slow play by the defense, because frankly, the longer it takes for this thing to get to trial, you know what law enforcement's doing? Investigating.
Yeah.
So the longer you give them to investigate, and believe me, they are not done investigating. They are still digging around. I guarantee you they're still looking for the knife.
Mhm.
Guarantee it. Now, are they out there like manhunt style? No, but they're definitely continuing to try to build a case, and that'll go up until the day of trial.
Sure.
I mean, like I've tried cases, like this where like it took 3 years and we were still getting discovery up until weeks before trial.
Yeah.
They're trying to always improve their case. If they're getting they'll send the DNA to different labs if they can get, if say for instance, the DNA technology improves over the next year or two, which is not out of the scope of reason. I mean, with DNA, it's unbelievable the advancements we see. So if there's issues that it's a trace amount and it's not a great profile that they were able to put together from what was there, and there's advancements in the technology, they're going to, if there's any of it left, to run another profile and build another profile on it, they'll do it. So it's really not a huge advantage. And Kohberger's in prison. Usually or he's in jail, but you're making that argument like they're trying to delay it when a guy's out, which typically is not the case in murder cases. Like the guy is incarcerated. Like he's not living a luxurious life. He's incarcerated. People are like, oh, he's wearing a suit. The reason he's wearing a suit is because of the incredibly, I don't know since maybe OJ that there was a case that's garnered this much interest. And we've had big ones. We've had Murdoch, the world was watching. But when you think about the level of media attention that case, the Idaho 4 case got when it broke, in recent memory, pre-arrest, I cannot remember a case that got that much media attention. Sure. It was it took over the world, man. It was even people that aren't into true crime were aware of it. You know what I mean? It was that type of case. So, in a perfect world, in order to, basically take that argument away from the defense about, what a person is wearing in a court of law and how that affects potential jurors, because people just think when there's a reason why when you watch a trial, defendants wear civilian clothing. Mm-hmm. It's because you cannot put a person in that orange garb there, sitting at trial, because it gives the sense to the jury that the guy's guilty. Subconsciously, you're just looking at a person in prison garb and you're like, oh, okay, well, the guy's guilty. He's in jail, So it's that's why, and with Kohberger, where they were televising everything, and because of the massive media coverage, and because of the potential to taint the jury pool, that's why they're allowing him to wear suits. Yeah. I would make the argument that every defendant should be able to dress in civilian clothing. But the reality is that 99% of most cases are not televised. Mm-hmm. Most court appearances are never seen, by the public at large. So it's why is the jail going to go through the problem of letting somebody get dressed in civilian garb, which is a whole process, as opposed to just grabbing all the guys from the jail that are on the call that day. They stick them in a holding cell and the judge calls them out. You know what I mean? So, but yeah, in terms of the delay, I mean, just it's the nature of the beast, man. It's not just Kohberger. It's every major case takes 2, 3, 4 years to get to trial. It's just the wheels of justice turn slowly, my friend.
Want to listen ad-free? Want advanced access to all of our interviews before anyone else?
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
You get every episode commercial-free,
so you can binge on true crime
until you can binge no more.
Search True Crime Today Premium Plus on Apple Podcasts now, or go to our podcast page and sign up now.
More of the Hidden Killers podcast next.